Thank you for joining the webinar. This will be a 30-minute look at the challenges you face when the client decides not to use your services during the construction phase. The construction phase, as you all know, involves putting into place a physical asset based on the services that you provided. And for a variety of reasons that we'll discuss, we think it is important that you be involved during this phase, during the construction phase. But when a client decides that your services will not be needed during the construction phase, this has both risk and practice management implications that we will discuss over the next 30 minutes. To begin with, we will look at the structure of a design, bid, build procurement system, because by and large, that's the vast majority of the construction that happens in the United States still uses a design, bid, build system, and this is what the talk is geared towards. We will review the roles and responsibilities of the design team in detail so that we can understand what is involved if the client decides they will no longer be using the design team during the construction phase. We'll then review two different scenarios that most often come into play and how to manage those. So let's set the stage. Now, as you know, in a design, bid, build environment, there are two separate contracts. There's the contract between the design team, that's you, and the owner. And your responsibility is obviously to come up with a design solution for the owner's needs, for their program requirements. And during the contract phase, during the construction phase, you will be responsible for providing an interpretation of what those documents mean and administering the contract on behalf, administering the construction contract that exists between the owner and the contractor. Now, when the owner enters into a contract with a contractor, when they give them that set of construction documents, they're giving them an implied warranty that the construction documents have sufficient information for the contractor that allows them to price the project, schedule the project, and has enough information for them to complete the project for the price that they agreed to in the contract. This is called the Spearman Doctrine, and this is something that was developed by courts saying that, hey, contractor, you do have some kind of assurance from the owner that the information that's provided to you and on which you base that information is sufficient for doing the job. Your obligation as a design team, as we've discussed in earlier programs, is that you meet the standard of care. Now, the concern that you all and we have when the owner says, hey, design team, you don't need to be involved in the construction phase, is that if the contractor alleges that the construction documents that you prepared did not have sufficient information, you're not there to rebut that information. And those allegations between the owner and the contractor that the contractor is making that there's not enough information will eventually morph into an allegation, most likely from the owner, that your services were negligent. So that's the concern that you have from a risk management perspective when the owner decides, for whatever reason, to limit your role during construction. So let's talk about the three roles that you typically have in a consulting practice as an architect or engineer. You're providing consulting services. Oftentimes you're involved from the initial stages, and this is really more of a cerebral exercise. You can think of it in those terms, right? You're helping the client analyze their needs, what their desired solutions are, what their constraints are as far as resources, as far as what the entitlement process looks like if it's a land development project. And these services often culminate in you helping pull a permit for the owner so that they can start construction. But beyond pulling permits, you're often involved as an agent of the owner. You're involved in administering the construction contract. And this is when things become more of a contact sport because people are now relying on those documents that you produced to actually put something in place. So more questions are asked, things are concrete, forgive the pun, but now people are relying on these drawings to do something, and so your involvement becomes much more involved, and more importantly, it has to be done in a timely manner because there are resources on the ground now that are depending on you to provide guidance about what these documents mean. And then oftentimes, there are questions revolving around, well, what was included in the construction documents? What is not included and therefore should be an additional cost to the owner that the contractor is entitled to? All of these things may well come up during construction, and oftentimes it's up to you as the architect or engineer, if you have that role, to serve as in a quasi-judicial capacity. You're acting more or less as a referee, to call it as you see it based on the contract that is in front of you. So again, if you're not there during construction and you're not providing these types of roles, it could lead to a detriment to your position further down the road, as we'll see shortly. So these are the three roles that an architect engineer would have during the construction phase. And if you look at it in more details, right, you have these very specific roles that you typically do. You are processing shop drawings. Shop drawings, as you know, are communication tools. The contractor is telling you how they intend to construct the project, and you're reviewing the information and making a determination whether it meets your design intent that's been expressed in the construction documents. And we're reviewing these because when you're talking to the client, if they're deciding that, hey, we don't want to use you during the construction phase, they have to understand that somebody has to step into this role to work to have some assurance that what is being done actually is indeed a reasonable solution that the contractor is building. You're also obviously conducting observations and evaluations, and this is also often very necessary. It allows you to identify issues and advise the owner on how construction is proceeding. You're providing essentially another pair of eyes for the owner to have some assurance that what is being done makes sense. This role is really, if you still have it, some owners decide that you don't have this role anymore, or your role is really just to advise the owner more likely about the nature of the work. But the owner will really benefit from somebody being able to say, hey, this does not meet the requirements of the construction documents. It could be in an advisory role. You may actually have the authority, but being able to flag any issues that come up as it's being done is much better than finding these things out after all is said and done, because nobody caught it. So again, the owner has to be cognizant of the risks that they have if they're choosing not to involve you during construction. And construction almost always involves changes. There could be a differing site condition, the change in the owner requirements, All of these changes have to be negotiated in a contract, in a change order to the contract. And oftentimes it's you in your role as an engineer and architect who works out these changes and make sure that both parties execute these changes and everybody's on the same page. If these things are not done in a timely manner, they don't go away. They just become claims later down the road, and clients need to understand that. And then finally, recommending payments, percent completes, processing pay applications. Determining how much of the work has been completed is essential to successfully manage any construction project. The owner oftentimes has taken out a loan, and the banks certainly want to make sure that what is being paid for has actually been put in place. And the owner obviously has to protect their interests by only paying the amount of money that reflects the construction put in place. If the project has been front-loaded by the contractor, that could lead to problems towards the end when there's simply not enough money and the contractor may not be as focused on completing the job in a timely manner. So what are the implications of design-only services? Well, if the client decides from the beginning that you will not be involved in the construction phase, then you can properly negotiate an increased fee and potentially have more time to address the challenge. And the reasoning is that, hey, client, you've told me specifically that I'm not going to be involved in the construction phase. Therefore, the documents that you're asking me to produce have to be more robust. They have to have more information than would be typically required. This could mean a larger fee because we have to spend more time to be able to make sure that all of the information that the contractor needs or more information is reflected in the construction documents. And this could mean a larger fee and more time. Now, if the client hires a third party to administer the contract, that's one way that owners are addressing the increased responsibility portion, is that they're simply hiring a construction manager. And then these items will be done by that construction manager. But if they have not decided to do that, then the client has to be very aware that they are going to be doing more during the construction phase. They will have to interpret the construction documents. They will have to process all of the changes during construction, and processing payments to the contractor becomes much more involved by the owner, because they have to make sure that they are in compliance with the covenants that they have with the lender and certifying that what is put in place, what is being paid for, reflects what has actually been put in place. But the other practice management issue for you all is that you have a reduced opportunity to learn from the contractor. During the construction phase, you're doing shop drawing reviews, you are aware of industry developments, how contractors are doing construction nowadays, how do they look at your design solutions, how are they reading the documents, you are learning about developments in the industry, and there's really greater knowledge transfer between the design team and the contractor when there is communication happening between you all. So you get to understand what the challenges are of the construction industry, have a better idea of what the current challenges are. And so that makes you a better design team. That makes you a better advisor to your clients. And so the implications of this could mean that you are simply reduced to a role of just, hey, we just need these guys to pull the construction permits and we will handle it from that point on. And that's really a place we don't, in the Victor program, we certainly don't think that that is a preferred position, because it diminishes your role and minimizes your chance to be part of the solution when if there is a problem. So the implication is that, hey, your concern is that the drawings and specs might not be used as intended, or they might not be substantially adhered to by the contractor. And if the problems subsequently occur, you may be entangled in a dispute based on allegations that the documents were negligently prepared. You will have to essentially conduct your defense without the benefit of having observed the construction, and that could really weaken your position. Of course, if the documents were improperly followed, you will generally not have any liability because obviously the contractor did not fulfill their obligation. But the reality and the practical implication is that you will still be incurring legal fees and expending time and effort associated with defending against charges of negligence. Second, you won't have any opportunity either before or during construction to resolve ambiguities or find and correct possible errors in your drawings before it becomes a problem. Obviously, correcting problems on paper is much cheaper, faster, and easier than correcting them in the field. And the less involvement you have to actually understand what's going on, then the greater chance that there will have to be field corrections that could be more costly. And you just simply don't have that chance to mitigate the effects of any problems with the construction documents. And the issue then becomes, well, if you are not providing these evaluation services, there's reduced likelihood that these deficiencies are corrected in a timely manner. And so you will be reduced to try and prove in subsequent litigation that the problem was the result of construction deficiencies, not design deficiencies. It may be possible to do that, but this could well have been avoided if you had provided the services during construction. So oftentimes what happens is that there are two different scenarios. Oftentimes, in one scenario, the client says from the beginning, hey, you know what? We don't need construction phase services. And so let's get your proposal in and let's just look at what is required to complete the construction documents, and then we'll take it from there. Or the more challenging situation is that they decide to terminate your services during design or shortly after approval by the authorities, meaning you've gotten the permits in place. And this is a complete surprise to you. So remember that even if the client tells you, hey, you will not have any construction phase responsibilities, you still have the risk of liability associated with being the designer of record, right? That doesn't go away. You still have provided a design solution that you've taken responsibility for. So you still are on the hook, so to speak, to make sure that the design solution meets the standard of care and so on and so forth. So you still have to educate the client about that piece. You also have to educate the client about the practical implications of having you removed from involvement. And we've gone over those reasons and what that means for the client. So the client has to either spend resources to be able to do those services on their own or hire somebody else. Whatever the case may be, that piece that you have to communicate that piece to them. And then finally, you have to make sure that your professional services agreement reflects that you do not have construction phase responsibilities and that there are appropriate protections in place. Because if your standard agreement or the client's standard agreement assumes that you'll be providing construction phase services and the contract says one thing and what you're doing is different, you want to make sure that that what you're actually responsible for is reflected in the professional services agreement. Now, if that's the case, the place to go to, as always, if you can find it, is in the standard form agreements, and the EJCDC E500 has that type of language where it assumes that you have no construction phase responsibilities. It starts out by clarifying that with the exception of such expressly required services, you have no design, submittal, including shop drawing review, or other obligations during construction, and that the owner will assume all responsibility for providing these services during that phase. And then it goes on to, obviously, what you want to make sure that you have is a waiver of claims, recognizing that you do not have a responsibility for items that come up during the construction phase, as stated here. Obviously, the client may well have some concerns that if you are indeed stepping in and providing interpretations, that you will be responsible for those, and that's fine. But just be aware that if you do decide to step in and provide these things, that you will be held responsible for that, and that's as it should be. So be prepared to enforce your terms. Know and enforce the requirements of the professional service agreement. If you said at the beginning that you're not going to be doing these services, and the client calls you up and says, "Hey, we have an issue," or you're getting communication from the contractor, then it's on you to make sure that you don't that you know the terms of your agreement, and inform the owner that, hey, you told me that I'm not going to be providing these services. You have to find some other solution. If the client at that point has a change of heart, then it's on you to negotiate a fee and amend your professional services agreement accordingly, so that, again, your agreement reflects that. So what happens if the client decides to terminate your construction phase services and you had no idea that was going to happen? And this is not that unusual for the client to decide to go in another route, or to say, hey, you know what, we can just take it from here. And the thing that you need to understand is that there may be state-specific provisions that may require the involvement of the original designer, and some states do require that you be involved as the designer of record, but you would have to find out if that's the case in your particular situation. But in most cases, your contract governs the involvement of the original designer. And the reality is that the owner has a termination for convenience clause. That's often the case, which means that for whatever reason, if the owner decides to terminate the contract, they can. So the solution is to make sure that you have enough leverage to at least get reasonable terms in your for your contract amendment. So what helps oftentimes is a strong ownership of documents provision in the professional services contract, because really what you have is a set of documents that you're providing to the client, the instruments of service. So you want to be able to say, hey, you know what? I have all of these rights to these instruments of service until all services are complete and all outstanding payments are received. So that is the type of position that would give you the ability to negotiate an appropriate addendum to your contract. that reflects that you no longer have responsibility for construction. And so this is the sample language that you can adapt for your needs. And it's clear that the terms of this addendum shall supersede and supplant any and all contrary provisions or understandings contained in said agreement or otherwise concerning your services. And so you recognize what's going on. Pursuant to your directive that I no longer provide construction contract administration services, my services, number one, are deemed to be complete, right? We're done. That's what you want, client. This is what the addendum says. That I will have no design, interpretation, review, or evaluation obligations during construction. And that client will assume all of these responsibilities that go along with such terminate with the fact that I no longer have construction phase services. And obviously you want that waiver of claims so that you are not, at least between from the client, that you have some semblance of protection from claims that happen during construction because you're no longer involved. So hopefully this provides you with some necessary background information, some issues to think about. Obviously, in an environment where unresolved changes are going to be costly, I think it behooves the clients to understand what the implications are. But at the same time, you have to be able to protect your interests, try to educate the client, and make sure that your agreements reflect their decisions not to involve you. So let me leave you with these three thoughts. Do not assume that an owner will want to have you involved during the construction phase. They may have a change of heart. So when you're developing your scope for design services, always price those services properly so that you're not relying on the fact that you'll be providing construction phase services later on. Examine your contract and any contract you're asked to sign on how your responsibility during the construction phase is outlined, and make sure that you understand what is being asked of you, how often you're supposed to be on site, and price those services accordingly. And beyond contracts, the key to protect your interests is to make sure that you're communicating with your client clearly and document any involvement during the construction phase so that you're protecting your interests, especially when the client does not give you a clear role during the construction phase, but they are contacting you with additional questions and so on. It's on you to make sure that you know your contract, that you're responding clearly, and that you're documenting any issues that you're aware of appropriately. So that brings us to the end of this program. I hope you found it useful. I just want to leave you with a screenshot of our homepage for the School of Risk Management. We have a lot of tools available for our insureds, resources that are designed to help you manage your risk. If you haven't set up an account with us, so we encourage you to do so and check it out. There's the Contract Sifter online platform for continuing education, and lots of tools and resources that are available to you. So keep an eye out for that survey that will come out. And if you're an AIA member, provide us with your number. And as soon as I end this presentation, you should be getting an automated email that will allow you to download your certificate. Thank you very much for your attention, and I hope you have a good day.